In the halls of justice, every word can change a life. Today, the court faces choices between truth, trust, and second chances. Bonds tested, tempers rise, but only one voice will stand when judgment falls.
Thank you.
Thank you, Your Honor.
Sir.
Your staff, have a great day.
You do so. Court calls case of the People versus David Knight.
Good morning, I'm Jake on behalf of Mr. Knight.
Your name, sir?
Good morning, Your Honor. David Knight.
Thank you.
Judge, in this matter, we'd like to set an exam.
Coverage complete.
Yes, Your Honor.
People have their witnesses available the 8th.
Judge, I have a trial with Judge Kuhnke starting the 17th. Is it possible we can move this out? Or
The courtroom opens with calm but caution. A simple adjournment request sets the tone. December 11th, another date, another waiting story. Each case here carries its own silence, where decisions are delayed, but destinies are already shifting.
I know, but I can't be here on the 17th. I'll have somebody cover it. Wait, let's do it the 17th, Judge.
The 18th, you mean?
I'm sorry, the 18th, yes. And may I address bond when appropriate?
Yes, you may. Let me set preliminary examination in this matter will be set for November 18th, 2025, 9 a.m. That is before Judge. I don't think so.
Judge Washington.
That's before Judge Washington. All right. Chance to bond.
Judge, it's my understanding that
Next stands David Knight, accused, composed, and waiting. The defense asks for leniency, a tether, a chance to stay free for his daughter's hearings. But the prosecutor's words cut deep, a story of violence, control, and fear inside the home.
he agrees to a tether. He's in neglect court regarding his daughter. He would like to attend those hearings in person, and he's not a flight risk. Again, he would agree to a tether. He's posted bond on his other matter, so he's asking if the court would allow a PR bond in this matter.
Response.
I would object to any reduction in bond. In this case, he was present with the victim and their child, and the victim because he had went through her phone and knew she was cheating on him. He then put his hand around her neck and strangled her, broke her phone. And
the air turns heavy as the charge is read aloud. An argument turned physical, a moment that changed everything. For the state, it's clear-cut. For the defense, it's a dispute. The judge listens, but justice does not bend easily.
Bond. I believe he had posted bond, right?
Yes, sir.
Well, right, but he's
I'm sorry.
but he's on bond. He had just posted when this allegedly occurred. Is that right?
Yes, Your Honor. He disputes what the prosecutors, what they're stating, but yes.
Understood. But he'll have a preliminary examination to have that looked at. Motion for bond reduction, given those circumstances, is denied. Bond will continue. Thank you.
Thank you, Your Honor.
Thank you. Thank you, sir. Court does call the case. People versus Thomas Gay.
Your Honor, we have the people.
The defense pleads once more, mercy, understanding, a second chance. But the facts remain unresolved, and the risks are too high. With firm words, the judge denies the motion. Bond continues, and the tension lingers in the quiet courtroom.
The possible resolution. The prosecutor and I have spoken and possibly even resolve this before the next hearing.
Probable cause conference will then be adjourned to November 25th, 2025, 9 a.m. That's a Tuesday. Bond will continue.
Thank you.
Court calls case People versus Alicia Allen.
that's justice for the people.
Good morning, Your Honor.
Good morning.
Assistant Public Defender Brian Bowling on behalf of Miss Allen. Can you state your name for the record?
I'm Alicia Allen.
Your Honor, we're asking that this matter be set for an exam.
Another defendant steps forward, Thomas Gay. His attorney requests an adjournment, hoping for a possible resolution. The court grants time, November 25th. Sometimes justice takes patience, sometimes patience is justice.
For November 18, 2025, 9 a.m., that is before Judge Moore.
Thank you, Your Honor.
Thank you. Bond continue.
Your Honor, may I address one issue of bond?
You may.
It's my understanding that the last time Miss Allen was before you, you denied the request for her to be released to treatment. If it became available, I'd just ask you to reconsider that.
And Your Honor, I'm sure the court recalls when we were here before, I let the court know about my concerns, any change in her treatment, any change in her bond rather, including release to treatment, which is extremely unusual, but given the fact that this.
Then comes Alicia Allen, a familiar face before the bench. Her lawyer asks for an examination date, but the real plea is for treatment. She's battled addiction, but the system sees danger more than recovery.
Has treatment been arranged at all, or?
I don't believe so, Judge. There are other holds that she'd need to address as well. Just if it became available, we'd like to have her be able to have that opportunity to go into that program.
I mean, certainly.
The prosecutor speaks, a third offense, a child in the vehicle, danger on the highway. The courtroom shifts again, compassion versus caution. Even when treatment seems right, trust must be earned, not assumed.
Guards and controls regarding her release.
Okay.
So at this time, what I'll do is I'll again deny the request. But if you come up with something, certainly get it to the court and I'll be happy to take a look.
Judge refuses release for now, yet leaves a door open. Bring me proof, and I'll reconsider. It's not just a denial, it's a challenge. In this courtroom, redemption isn't denied, it's tested.